So we need to talk about an important update in a case challenging a state's rifle and magazine ban. Now, really quick before we jump into this video, I want to ask you guys to please do something for me. Looking at the analytics, there was only about 5% of all people here on the channel who have all notifications on. So if you're not aware, when you subscribe to the channel, there's a little bell icon that you can click, and that is to get notifications when I release videos and other types of posts. So if you could click that bell icon and then put on all notifications and activate to get those notifications, that is one way to ensure that when I release a video here on YouTube, YouTube will actually send it to you. So again, thank you guys so much for all of your support. Make sure you are liking the video and subscribing and click that bell icon. Now, as I mentioned in the intro, in this video, we need to talk about what is now happening in multiple cases challenging a state in their ban on so-called assault weapons and their magazine bans as well. The cases we're going to be talking about originate out of the state of Illinois, and it's a challenge to the state of Illinois and their new law, which is the Protect Illinois Communities Act, also known as PICA. These challenges come off the heels of a recent Supreme Court order denying emergency review in all of these cases because the Supreme Court wants a final merits case. They want a final decision on this issue. Well, a bench trial recently took place on the final merits of all of these cases, and at that hearing, the judge signaled very strongly that he still believes that this ban in Illinois is in fact unconstitutional. He also requested that the parties here, both the plaintiffs and the state of Illinois, that they submit additional evidence, additional support for their cases, for their arguments. And Illinois just recently submitted 63 attachments and over 3,500 pages of exhibits and documents that they claim support their rifle magazine ban. Now, if this seems like it's overkill, that's because it is, and it's probably a way that the state is now trying to attempt to delay this case for a little bit longer and delay and potentially stall the final decision that is set to be issued by Judge McGlynn. Now, you might remember that originally in multiple of these cases, the district court issued a preliminary injunction that was intended to halt the enforcement of PICA until this case reached a final merits decision. Judge McGlynn outlined how he believed that the plaintiffs were likely to succeed on the merits of their claims that Illinois and their rifle and magazine ban did in fact violate the Second Amendment. However, the state of Illinois appealed that injunction up to the Seventh Circuit, and on review, a liberal and biased three-judge panel on the Seventh Circuit overruled his preliminary injunction. Now, in coming to that decision, the Seventh Circuit three-judge panel used an analysis that did not align with Heller's common use test or the recent Bruin holding either. Instead, the Seventh Circuit three-judge panel concluded that the arms protected by the Second Amendment do not include weapons that may be reserved for military use. That decision was then appealed up to the en banc panel in the Seventh Circuit, but the Seventh Circuit en banc panel denied review in all of these cases. That then led to multiple of these cases then seeking Supreme Court immediate intervention on this issue. But like I mentioned, the Supreme Court recently, at the end of their last term, denied review in a bunch of these Illinois cases. In that denial, Justice Thomas did make a statement. The only judge who would have granted it was Justice Alito, but Justice Thomas did write a statement, and he stated that the state of Illinois enacted a law that makes it a felony to possess what Illinois branded assault weapons, a term defined to include AR-15s. He went on to state that the AR-15 is the most popular semi-automatic rifle in America and is therefore undeniably in common use today. According to the Seventh Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of the arms referred to by the text of the Second Amendment. We have never squarely addressed what types of weapons are arms protected by the Second Amendment. To be sure, we explained in DC versus Heller that the Second Amendment's protection extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And we noted that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, recognizing the historical tradition of prohibiting the carrying of dangerous and unusual weapons. But this minimal guidance is far from a comprehensive framework for evaluating restrictions on the types of weapons, and it leaves open essential questions such as what makes a weapon bearable, dangerous, or unusual. The Seventh Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. By contorting what little guidance our precedents provide, the Seventh Circuit concluded that the Second Amendment does not protect militaristic weapons. It then tautologically defined militaristic weapons as those that may be reserved for military use. In my view, Illinois' ban is highly suspect because it broadly prohibits common semi-automatic rifles used for lawful purposes. It is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. But if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the cases reach a final judgment. The court must not permit the Seventh Circuit to relegate the Second Amendment to a second-class right. So although the Supreme Court denied immediate emergency review in these cases, Justice Thomas did make a strong statement and a warning to the Seventh Circuit and to the lower courts reviewing this issue. But in all reality, we know that lower courts like the Seventh Circuit and some of these judges do not heed those warnings, and they're going to come to the conclusion that they want. But now this case is moving towards a final decision in front of the lower court judge, Judge McGlynn, and recently held a hearing on this issue. The discussions at the hearing varied from distinctions between the military M4s and other military rifles and the civilian AR-15. Both sides put on witnesses to discuss whether civilian AR-15s are military-style rifles. Also, at the end of the multi-day hearing, Judge McGlynn brought up some historic riots back in 1917 in the area. He mentioned the atrocities that some African-American communities in that area were faced during those events. He also mentioned whether, things might have been a little bit different if those groups had something like AR-15s and other types of rifles to their disposal to potentially fight back. And so it was very interesting that you had the judge himself mentioning those incidents and how useful these types of rifles could have been in those situations. Now, again, at the end of the multi-day hearing, Judge McGlynn had issued some orders, and he ordered the parties to file briefs on the historical support and evidence that they have that shows and potentially relates to how these rifles and various restrictions and these magazine bans, either are constitutional or unconstitutional. What does the text, history, and tradition actually show in regards to these items? Now, all those briefs were due by October 21st, and the state here, Illinois, just issued their documents. They issued their briefs, their filings, their exhibits, and they flooded the court with a ton of documents, over 3,500 pages in exhibits as well, and they claim that all of those support this rifle and magazine ban. Now, in reality, this amount of exhibits and the 149-page proposed, finding of facts, in my opinion, is overkill. And once again, in my opinion, I think it's another attempt by the state of Illinois to try to overload the court with documents, try to overload the review of this case, and try to stall this out for as long as possible, delay it a little bit longer so that the judge here does not issue his final decision very fast. Judge McGlynn has stated multiple times and also during the recent hearings that he is going to be reviewing and considering all these documents. And I think the state took the strategy to just flood the court, flood all these documents, potentially have him review all of them, and maybe delay the consideration and the decision a little bit longer. However, I have a gut feeling that this is not really going to play out the way the state of Illinois wants, and regardless, I think Judge McGlynn is once again going to issue a favorable 2A decision, finding that the state rifle ban and magazine ban is in fact unconstitutional. But keep in mind, even after that, even if we get a permanent decision, a permanent injunction striking down this entire law here in Illinois, no doubt the state of Illinois and the defendants here are going to seek Seventh Circuit review. They're going to file an appeal up to the Seventh Circuit and probably also file for a stay of that decision. And then it's going to be in the hands of the Seventh Circuit to decide if they are going to grant that stay, preventing any positive decision from taking place here in Illinois. And then also, I have no doubt that they're going to take review of this case again. So that's just kind of where everything sits. I know a lot of people in Illinois and other areas are asking what's going on with this case. We had a ton of documents flooding the court today in response to that recent hearing that took place in front of Judge McGlynn. In my opinion, the state of Illinois is trying to delay this a little bit longer by flooding all those documents into the court, and we're going to have to see how this plays out. So if you guys have any questions, go ahead and comment down below, and I will try to answer to the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.